Your Honor. You're just by the page.
I understand that. I realize that.
Well, I didn't think you guys were that far apart, and we're talking about, a 3-week period, and hopefully we'll either have a deal on the 23rd, or we'll have a hearing, and I'll make a determination based on a full record. But let's get to that hearing, with the minimum amount of time and effort.
And Your Honor, just the way that we set up the order was that we would have another interim on October 23rd, not a final. But okay, I didn't know if that was.
Yeah, no. I'm just saying. As I said, to the extent that we need, we're going to have that hearing on the 23rd. It's on my live stay docket, so there'll probably be a bunch of other ones. If we have to have a full-blown evidentiary hearing, that'll be the next day.
On the 24th. Okay. Yeah. So we'll set it for the 23rd, and then you'll kick us if you have to. Is that
correct?
Correct.
Right? I mean, if we're going to need a couple of hours, then I'm going to have to do it on the 24th. But if it's just, presenting an order or, some just argument on one issue or something like that, then we could do that on the 23rd. But I wanted to be as responsive as possible.
Understood. Thank you, Your Honor.
Very good. Thank you.
If I may ask just one question, I was going back to my notes to be able to revise the order. Do we have a time on the 24th? Yes, on the 24th. Why don't we do it at 9 a.m.? Thank you, Judge.
Very good.
Court case should be starting in a minute, so give me about 5 minutes.
Yeah, and on the, on the 11 o'clock docket right now, I have one.
Hello?
I have 8 list days. Now, obviously, a lot of those will drop off.
Starting about 7 minutes early.
As we get closer, so and that's it for the day. So we may have a little bit of time there, but it's not like I'm going to have several hours.
Understood.
Okay.
All right. Well, thank you, Your Honor. The debtor doesn't have anything else to present this afternoon.
Anyone else, Mr. Burr, or Mr. Weiss, or Mr. Brookman?
Sounds good, Your Honor. Thank you very much.
All right. So we'll be in recess until my 2:30 hearing.
So.
Thank you, Judge.
Thank you, Judge.
Thank you, Your Honor.
So I need about 5 minutes here to get everything going.
Line unmuted.
So about 5 minutes.
Muted.
So about 5 minutes he'll be ready.
Recording stopped.
We'll be ready about 5 minutes. So I'm sorry about that. I'd rather be 5 minutes early than 5 minutes late. That's for sure. That's for sure. I'd rather be 5 minutes early than 5 minutes late. So. Boy. It's for the motions and all that stuff. Blah, 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 blah. Make me whole. That's all I know. Make me whole. Don't take my shares and don't try to make me whole. Y'all ready? Yo, you ready? This for the hearing? The link to bankruptcy motions? about 3 minutes.
Please mute yourselves.
When the court start, I will.
This call will be recorded.
All right, I think they're about ready. Okay, it's me again, the real crypto informant, X-rated penny, link to bankruptcy.
Conference recording
Hearing
started.
is starting, so here we go. Part 2. The hearing should be starting any minute. He said he'll be back at 2:30, so it's 3:30 Eastern, 2:30 Central Time. They're down there in Dallas, and unfortunately I'm on the East Coast. That's why I keep showing up here early. So hopefully it works all out. And I appreciate you guys staying with me, sharing with me on my page. Appreciate it.
Everyone, please mute your phones.
My phone is muted already. We waiting.
All right, good afternoon. It's 2:30 on Friday, October 3rd.
Here's the judge here.
We're here in the continuation of the hearing, which started this morning in case number 25-90186. Parties have already made appearances. All right, Mr. Schwartz, go ahead.
Thank you, Your Honor.
Mute your phone. All right, let's activate the hand-raising feature.
Line muted.
Thank you, Your Honor. Sam Schwartz with Debtors. Can you hear me?
Yes, I can hear you.
So, Your Honor, I think at this point we are now at the debt financing motion, where we were going to go next. In connection with debt financing, Your Honor, we have exhibits 1, 2, and 5 and 8. 1, 2, and 5 are the declarations in support of the financing, and then exhibit 8 is the revised and updated budget that was attached to the 1919 motion. So those are properly in front of you in connection with this presentation. I think, Your Honor, there are a few things to note. We went through at the first day hearing some of the math and the numbers and the issues that are in front of you. I'm not going to go there. I'd like to talk to you what's happened in between. As the court, I'm sure, can surmise, there's been a great deal of negotiation over the financing. It has changed substantially. First, it's been reduced by over half, actually. The original financing proposed was $60 million. It's been reduced to total potential financing of $25 million. We anticipate, Your Honor, we'll need at least $20 million to finance the case through confirmation. There is a $5 million accordion, we were calling it, in the event there's cost overrun. Also, per the settlement agreement, those costs will be spread across the litigation trust and the closed-end fund. If those entities are properly formed, if they come through the plan, if enough people vote for them, based on then, Your Honor, the ultimate number of customers that end up in either vehicle. So we'll also be spreading those costs across the customers. That comes to that 5% estimate that we've done, but it's important to note that we'll also be allocating costs based on where people go. With that, Santon, Your Honor, has made many concessions. So, first, there are no liens on any of the non-linked to assets, meaning if there are assets that were allocated to customers in the purported economic interest, Santon has agreed not to take a lien on that. So Santon only has a lien on linked to's reserve securities. We did expand to give Santon liens on cause of action. And then we gave a couple of mechanisms for Santon to recover funds in the event there's a default, a maturity, and they're not paid, for example. So, number one, Santon has a confession of judgment now. It's one of the changes to the loan agreement, meaning if there's a default, Santon can come before Your Honor, present a judgment for the amount of money that it's owed. Subject to Your Honor entering that judgment, then Santon would be able to collect on the portfolio of all the assets based on its confession of judgment for what it was then owed. Would be a tool, Your Honor, to collect. We've also agreed that in the event of a default and issues with collection, that Santon can designate an attorney in fact, and that attorney in fact would be the chief restructuring officer, Mr. Stein, who would then be there to take securities, liquidate them, and pay Santon in connection with the debt that it's owed. And then last, in terms of changed remedies, there is some, we had considered a surcharge, Your Honor, for the actual necessary cost of preserving the value of this collateral. I believe the committee's highlighted for you in their papers that there are some cases that discuss equitable surcharge. We have issues with secured creditors and not secured creditors here, but we think there's a basis for surcharge down the road if necessary. And so we provided Santon with a lien on the debtor's surcharge rights, should that be necessary at any point in time. Quite a change in the suite of remedies and collection vehicles that Santon has from before we got here, Your Honor, number one. Number two, Your Honor, there were other parties that came to the table in prospective financing. As the Court's aware, I think we highlighted in Mr. Hamilton's declaration and Mr. Stein's declaration at the outset of this case, the competitive process we underwent to find financing here. There was one party that came to the table that had slightly better financing, Your Honor. We ran the math on that. In connection with that slightly better financing, we took that to Santon and said, look, we have a better proposal, ran the math with them. Santon did agree to reduce what is really a minimum recovery they have. It's called the multiple on invested capital, the MOIC as we call it. They've agreed to reduce that by $250,000 in connection with the other proposal that we had. So not only is the suite of terms and collection remedies vastly different than what we had proposed when we first came in front of you, Your Honor, the cost of the money has come down a bit. And I would note from the debtor's perspective, and I think in the debtor's business judgment, when we look at the cost of what it would take to switch horses at this point, Your Honor, and repaper a new loan with a new lender, the cost would greatly exceed what we would be able to get from anyone else who came together, including, I think, what Mr. Stein likes to refer to as the friction cost of paying Santon for what they've lent so far, the $10 million, not even calculating the cost of what it would take for all the professionals involved to deal with bringing a new lender to the table, which we think is a high six-figure and maybe low seven-figure cost. We do have an additional $250,000 of savings in getting to where we are today. But I would say, Your Honor, with that, the fact that I think the settlement's approved, what I highlighted at the last point in time, Santon has been an excellent trading partner, patient, and worked with us through all these novel issues, Your Honor, that to find a lender who would do this agreement with liens on collateral that is arguably less than the amount it's lending and take other forms of collection opportunities or measures is not something that you would see very commonly. And with that, subject to questions Your Honor may have or comments from other parties, we think that DIP financing, with all of its changes and improvements, I would argue, is ripe for approval.
All right. Let's see. I want to hear first from the committee, then I'll hear from Stan.
Thank you, Your Honor. Kenneth Paulette, Brown Rudnick. Your Honor, the committee supports the DIP motion as modified. I think, as Mr. Schwartz alluded to, this is a really unique DIP for a very unique situation where we have these customer securities and there's just not enough non-customer assets to get us from where we are today to a point where we can start returning those customer securities to customers because of the nature of private securities. And so it's been a real issue because, as Your Honor knows, the primary point of dispute that we have been able to settle with the debtors has been essentially who owns those securities. And being able to get to a point where we're not litigating that issue, which would have been tremendously expensive, and I think as we submitted our papers in support of the settlement, we think where we are today is better than where we would if we had litigated and won that issue. And so what we have here today is a really, I think, creative structure that does not determine that issue so that it can continue to be settled in a plan. And it is not reliant, as the original DIP was, on a finding on how customer claims should be considered, how the customer security should be considered, and paves the way to getting us to the kind of plan that we are looking to implement in this case. And I think I've said before, the committee is very reluctantly supportive of this in that we never should have been in this situation. The SPVs should have been set up. Link 2 should not have done what it did, such that it landed on day one with the facts that we've all had to deal with, where Link 2 simply didn't do what it promised everybody that it would do. But as we've said before, this is going to be a little bit painful. It is likely to wind up with about 5% of the customer securities sold. If we can reduce that, we will. But, I think it's a credit to Stanton that they were willing to, and Mr. Schwartz, that we could get to a point where we could solve the need for this case, the financing needs for this case to get to an end. And I would reiterate the point Mr. Schwartz made that, we believe, as we put in our papers, there is an equitable basis to have done this, even if the committee had been successful in proving a constructive trust, that, you've got to pay the freight to get people their stuff back. And so with all of that said, Your Honor, we support the entry of the DIP order.
All right, anyone else wish to be heard? My only, all right, does anyone else wish to be heard? Mr. Akmajan? Did I unmute you?
Your Honor, can you hear me?
Yes.
Thank you, Your Honor, and thank you to the ECC and the Father Schwartz for reaching this settlement. My only question is, I am a Link 2 customer. I have about 9 different companies on the platform that I purchased in the form of SPV shares. My only question is, can I get clarity on the treatment of Link 2 SPVs? If I select the liquidating trust option, will the Link 2 SPV shares have any claim to the equity of Link 2 as it emerges from bankruptcy as the manager of the closed-end fund? Thank you.
Yes, that's not a matter that's in front of me today. The only thing that I'm hearing right now is the DIP motion, the motion that was filed at docket number 16. That your question is a matter for a different day, not today. So that'll be considered at some other point. Okay. Does anyone wish to be heard on the dip motion and the dip motion only?
Your Honor, can you hear me?
Yes.
Thank you for the time, sir. I don't know. I would like some clarification before I even voice this objection. It sounded like Mr. Schwartz and Mr. Arlett. I'd like to thank both of them for getting to this resolution in such record time. It's phenomenal. Very excited about it. I will say that it sounded like Mr. Schwartz had said that the DIP lender had agreed to only put a lien on linked to reserve assets, but then followed it with they are still looking for recovery if Link 2 cannot make those payments from customer assets. It just seems to be like an inherent conflict or contradiction there. And I was just asking for clarification on that point.
Yeah. Well, Mr. Schwartz, go ahead and do it, but I understood that there was no lien on the assets that are allocated to customers.
That's correct, Your Honor, although it is anticipated that there will be 5%. That we were talking about a customer fair market value, Your Honor, will be the cost of administering the case through confirmation. So there will be, the expectation is there will be 5% of customer accounts that will have to be used to get to the finish.
Right. Okay. Great. Thank you. All right. Anyone else? All right. The only concern that I have with the order is in paragraph 15B, and as is traditional in the Southern District, the DIP remedies period, it is the lender has to come in to seek to enforce its right, as opposed to the debtor being incumbent upon the debtor. So I think that basically, if there's been a default, and obviously it terminates the use of cash collateral, et cetera, they can call the default. But if they want to exercise rights, they can, on an expedited hearing, we'll give you a hearing in as quickly as we have time to be able to enforce rights and remedies, as opposed to the exercise calling a right. So maybe take a look at the last sentence of paragraph 15 and kind of flip it, and then with that, I don't have any other comments to the DIP motion.
Thank you, Your Honor. Just confirming that the court does approve. I think based on the evidence, there's no reason to not make a good faith finding under 364E. I want to make sure.
Everything else I've approved, and I was going to get to my ruling, but this was just my only comment on the order.
We will run something past Stanton, Your Honor, in the committee, and agree.
I think Mr. Stark has seen this before, and I think that's one of the things we uniformly enforce.
Fair enough, Your Honor. I think it's the first day hearing. Ms. Polnick put it as you can set the table, but you cannot carve the turkey without court authority. I think that's how we call it. So
I think that's exactly how she called it. Exactly. So with that, so based on the evidentiary record, which is pretty clear that the debtor needs to be able to run this case and needs the money to be able to run this case, I think under the circumstances, the DIP is appropriate, market-based, and on that basis, I will find that the lender has acted in good faith, and I think that the remedies, with that caveat, are appropriate under the circumstances. So I will go ahead and approve the final DIP, and with that one change to paragraph 15B, I'm prepared to sign the order.
Thank you, Your Honor. I think then, Your Honor, that takes us to docket 79, which is the motion for use of the Ripple proceeds.
Correct.
So, Your Honor, as a quick refresher, these are the monies that were related to the debtor's participation in a tender offer from Ripple Labs based in December of 2024. We've discussed, I think, plenty how the debtor got to that process, how former management participated in the tender, and where those shares came from. I think the evidence is in front of you in Exhibits 3 and 4, in connection with who owned those shares, that they were owned by Liquid Shares, although the economic interests are a separate issue. And so, in our resolution with the committee, we have come to terms that financing this case, the most efficient, affordable way to do it is to use that cash. It is in the debtor's possession, and it is on their books. We've highlighted for you, Your Honor, in our papers, Haber Oil from the Fifth Circuit. I know the court had concerns about Rule 7001. We highlighted for Your Honor that the burden is on the customers, not on the debtor, to bring an adversary if that's what they wish to do. So I think procedurally we're here in an appropriate form, Your Honor, and I think without running down that rabbit hole of the arguments that the committee feels strongly about and the debtor feels strongly about, that is exactly what we're settling here today. It's important to note as part of the settlement that the Ripple holders that were affected by this particular transaction will get a rateable interest in their recoveries going forward, meaning we expect it to be 5%, is the cost of running the case. If it turns out the use of this cash is 6%, of that, there'll be some adjustment across the customers. So there'll be a claim, if you will, a rateable claim based on the costs among the customers generally. So that's evened out once we get to the finish line, Your Honor, and know what the costs actually are. So with that, Your Honor, subject to what the committee may have to say and other comments from other parties, I think also with the settlement in hand, docket 79 is right for approval.
All right, Mr. Elliott.
Thank you, Your Honor. As before, the committee supports this. As Mr. Schwartz has said, these shares shouldn't have been sold when they were sold, but they were. And now that we're here today at the point where we're likely going to be needing to sell some customer securities to fund the case, you might as well use the cash that's available, as you don't need to borrow it and the costs are lower. That said, the one thing I want to make clear to people, and I think Mr. Schwartz alluded to, is the sale of those Ripple securities caused about a 3% shortfall, so that there's about 97 shares for every 100 that should be there. And when we talk about a 5% haircut, we're not talking on top of that 3%. So that the goal will be that at the end of the day, everybody's got 95 shares of the 100 shares they should have, including Ripple holders, so that Ripple holders will not be prejudiced by the use of this money any more than any other customer is going to be prejudiced by the cost of this case.
All right, thank you. Mr. Brody? Oh, hold on a second.
Thank you, Your Honor. Again, for the record, Josh Brody from Cleary Golly on behalf of the Swagger parties. And we had filed a reservation of rights on this motion with some claims that we think relating to the how the Ripple shares made their way to the debtors. We don't have any objection to the use itself. It's just to make sure that nothing in the order would prejudice our claims with respect to relating to it. I don't view that, would not think it's controversial yet. I think at one point I asked debtors counsel to confirm it, but we had not heard back. So I just wanted to put that on the record.
Nothing here is intended to impair or modify the claims of Mr. Brody's client.
Okay, thank you.
Yeah, and I'm not making any finding as to the character or the nature of the shares. I'm giving the debtor the authority to use the proceeds. I'm not making any finding as to the nature of the shares and who owns them or how they're done. That's not what this is about. All right. Anyone else wish to be heard? be heard on the Ripple proceeds motion? If you're muted, you can hit 5-star. Dr. Boriani, do you wish to be heard? Hit 5-star one time. All right. Hearing no further objections. Based on the evidence in front of me, I think that the use of the Ripple proceeds to fund the case is a proper exercise of the debtor's business judgment. This is. I have to defer to the debtor's business judgment on this issue as to the best way to fund the case. I think under the circumstances, obviously nobody wishes we were in this position. Nevertheless, I do believe it's a proper exercise of the debtor's business judgment, so I will go ahead and approve the motion and enter the order. And it's still the order at number 79, or is there an updated order?
There's not an updated order, Your Honor. It's still the order at 79.
Okay, so just give me a minute.
I don't know if that he just did that for the Ripple shares or that for all the shares that's going to be there. He just settled that for the Ripple shares, look like. Or sounds like. I might ask the question.
Hand raised.
All right, that order has been signed and sent to docketing.
Thank you, Your Honor. I think that leaves then the ad hoc committee's motion is up next.
All right. Mr. West?
Good afternoon, Your Honor. Can you hear me okay?
I can hear you fine, sir.
Okay, great. Colin West of White and Case.
Line unmuted.
The ad hoc group of equity holders. We filed a motion to appoint an equity committee because it has become clear to us that the current estate fiduciaries are not and have not been considering the interests of equity holders. In their objection, the debtors have now acknowledged a duty to do so, and they argue that current estate professionals are doing so. And we think it's good that they've now acknowledged that duty, but the problem is that when they're not addressing the court, when they're just running the cases day to day, we believe they've taken the opposite approach. They have, in fact, expressly disclaimed any obligation to represent the interests of equity holders, and I'd refer the court to the email that was attached to our motion at Exhibit A, which was referenced earlier this morning. What is strange about this, Your Honor, from our perspective, is that if there is ever a case in which the debtors should be thinking hard about the interests of equity, it's this one. Which brings me to the issue of solvency. Your Honor, we broke earlier today because Your Honor had a hearing in a different case. Another large Chapter 11. In that case, Your Honor, I understand you've got a fairly typical type of capital structure, the kind one is used to seeing in Chapter 11 mega cases. My understanding is $1.4 billion in
unsecured notes alone. This is not that case. In this case, at the petition date, you had, number one, customer claims. It's very clear from today and the other proceedings that we've had in this case, at least according to the UCC, that what the customers want is the benefit of their bargain through the allocation of their securities, essentially as originally intended in one form or another. But those securities are there, Your Honor. So if you assume that the benefit of the bargain approach is the right approach, on the petition date, with the limited exception of the 3% of Ripple shares that Mr. Ouellette mentioned, the securities were there to make that happen in one form or another. And you had $2.1 million in general unsecured debt, mostly trade debt, as I understand it. On the asset side, in addition to the, quote, customer or platform securities, you have the reserve securities, which are not deemed allocated to customers. And these are private companies. People might not agree on value, but the debtors say they're worth about $17 million. That's it. That's essentially the disclosed capital structure of the company as of the petition date. That's not hopelessly insolvent. To the contrary, that's balance sheet solvency. The argument is that professional fees, in this case, have or are going to make the debtors insolvent. But, Your Honor, we are at least within striking distance here. And that's all assuming there's zero value to the platform, the technology, the intellectual property, the business. As Your Honor has heard today, there are people out there who believe that the business has real value. At this point, we don't know for sure, but the debtors in the UCC want you to just assume that away, and on that basis conclude that the debtors are hopelessly insolvent. And look, I know the debtors have said a lot, and maybe we'll say more about potential regulatory liability, but those claims haven't even been asserted yet, let alone proven. There is not even an update on the progress of the special subcommittee's investigation. You can't just abandon the interests of a stakeholder based on speculative, unproven, unasserted claims. But that's what has happened from our perspective and continues to happen. For example, the debtors and the UCC have entered into a settlement that, in our view, boxes out equity, contemplates no recoveries for equity. Equity isn't even the residual beneficiary of the litigation trust to the extent that customers achieve a full recovery, even under their own standards for what that means. And I know the UCC, on reply, came back and said, no, we haven't made a decision. No one's made a decision about who the beneficiaries of the litigation trust would be. In their original statement in support of the settlement, docket 583, paragraph 42, they seem to be pretty clear in interpreting the settlement the same way we did when they said that the trust would pursue claims, quote, on behalf of linked to customers and creditors. Now, even if you accept the UCC's attempt to walk that back, and their argument that we haven't yet determined how the trust interest would be allocated, and it appears they're suggesting the possibility that shareholders could be allocated trust interest. Okay, in that scenario, who's going to be there to advocate for the interests of equity as that gets determined? All of this, Your Honor, may not matter in the case where there's $300 million in unsecured notes and general unsecureds are projected to receive the 14-cent recovery. But this is not that case, and it does matter here because we are at a minimum on the cusp based on known assets and known liabilities. And I just want to finish by addressing a few of the relevant arguments made in the UCC's and the debtors' objections. First, the UCC says this is an effort to shield shareholders from litigation. It is not true. The court can limit the scope of an equity committee, and on behalf of the ad hoc group, we would agree that the scope of the equity committee should not include any litigation defense on behalf of shareholders. Equity committee's role, from our perspective, would be to pursue the interests of all equity holders in linked to. The second argument that's been raised is cost. The UCC says it's too costly to have an equity committee. As I these are subject to court approval in all instances. And then last, Your Honor, I just want to address this argument that the UCC made that somehow we've agreed that the litigation claims that have been vaguely referenced as claims that would be pursued by the trust, that we've conceded the value of those claims or are advocating for the value of those claims. That's not the case. We don't know what the claims are. We don't know who they're going to be pursued against. But we're reading the UCC's motion and the debtors or the UCC's position as we've interpreted it, that the UCC believes those claims have significant value. To the extent they do, it was curious to us that there was no possibility in the settlement as we read it that equity could benefit from that value. Your Honor, that's all I have. Obviously, we've laid our arguments out in our papers, but if you have any questions for me, Your Honor, please let me know.
All right. Mr. Schwartz? Well, actually, let me hear from the U.S. trustee first. Mr. Jimenez, thanks for coming, because I know the circumstances. Oh, let me get you. Hit 5-star. No, I think you're hit 5-star. All right, go ahead. I think I unmuted you.
Thank you, Your Honor. Andrew Jimenez for the United States trustee. The U.S. trustee is not taking a position on the motion that was filed by the ad hoc group of equity holders. I think the court has already been informed that prior to that motion being filed, a request was made to the U.S. trustee, and that request was denied. So we're not taking a position with this motion. We are, however, if the court decides to appoint an equity committee, we'll be standing by and ready to take the necessary steps to make that appointment. But we're not taking a position on the motion.
All right, thank you. All right, Mr. Schwartz.
Thank you, Your Honor. I think Mr. Alep is going to go first on that committee.
Okay.
Thank you, Your Honor. Kenneth Alep, Brown Rudnick for the committee. Your Honor, I have trouble understanding which case Mr. West has been looking at, because Mr. West said that this is the kind of case an equity committee, and I could not disagree more. What we have here is a business that is stopped. It is a business that came in on day one to admit that essentially fraud had been conducted against its customers. The kind of case that has a potential for an equity committee is where you have an operating business that has a potentially temporary setback. It's got a liquidity issue, but it's a good business. It generates value, and somebody's going to have to own it. But maybe, secured creditors or even unsecured creditors may look to lowball that valuation because they're getting paid in equity. This is not that case. This is a case that is proceeding to, there are essentially no assets of the debtors. Mr. West came in to the U.S. trustee to say that he thought there was $150 million of reserved securities, which I don't know how you can come in on day one and look at the fights that are about to happen over a $60 million dip and think that maybe there's that kind of value, but there's not. So what we have here, Your Honor, is a fraud case. There is the securities to return those securities with one big exception to customers in satisfaction of those customer claims. But that one big exception is a big one. The company sold 3% of the Ripple shares. Ripple shares have been going up considerably since that point, and all of the $20 million that was put aside for that, that's going to be used for the cost of the case. This case has a budget of $35 million. So the $16, $17 million of reserved securities, as Mr. West said, these are private securities. They're not easy to monetize. And so we've got a $35 million hole to fill just to get customers back to where they should be on their customer accounts. And then we turn to, as he said, just $2 million of trade debt. Easy enough. But then we could turn to the fact that as the debtors,
the debtors appear to have violated every single securities law on the books. And the SEC is not going to come in and assert a claim against it's going to hurt customers. Those kinds of penalty claims are subordinated, but they rank ahead of equity. And Mr. West comes in and says, well, that's speculative. This is an extreme remedy that Mr. West is seeking. He sought the appointment of an equity committee from the U.S. trustee and it's been denied. And he's come in and he's offered no evidence. The appointment of an equity committee is very uncommon. And here we have no evidence. We have only speculation, and not very informed speculation. I think as we told Mr. West Klein, if somebody thinks that the reserve securities are worth a lot, come on in and bring your checkbook. Because if equity holders believe that those reserve securities have tremendous value, look, there's a really easy way to get the value of those. And that's to come in and try and have an auction for it. At the end of the day, though, as Mr. West said, one of the things that is making this company insolvent is the cost of this case. And coming in and saying customers should bear even more costs so that Mr. West's clients can run out an equity option. It's just irrational. This today is a liquidation case. Maybe there is value in the platform, but I point to that every single kind of financial firm by law is ineligible for Chapter 11 because restructuring financial firms doesn't work. If a bank becomes insolvent, it's seized by the FDIC. You sell it the day of, or you don't sell it at all. If a broker-dealer goes insolvent, customer accounts are transferred immediately, and then it's liquidated. Commodity broker goes insolvent. Again, it's liquidated. It would be great if there's value for the platform, and we'll hear out Mr. West's clients if somebody's willing to come in with a very big check and try and run that. But in the context here, customers are being asked to fund Mr. West's client's equity option where they've come in and provided no evidence, none whatsoever, that the debtors are solvent today, that the debtors could be solvent. The debtors somehow could avoid regulatory penalties for everything that they've done. And I also note it's not just regulatory issues. It's been widely reported, and I think admitted by the debtors, that the way that they funded their operations in the last, at certain points in time, was to charge customers undisclosed markups. That they advertised that they had a price for these securities, but really Link 2 was on the other side of every single trade, and it was charging a considerable markup, one that's larger than FINRA permits. And so customers may not only have claims for their accounts, but they may have claims for the amount that they were defrauded by Link 2 to pay more than those securities were worth at the time. And then there's the question of people that are no longer customers, where Link 2 went out and lowballed people to buy their assets from them. There's a tremendous universe of potential claims here. As Mr. West said, the UCC, the committee is going to hold everybody who did this accountable. We don't know how much we're going to be able to recover. If we can recover as much as needed to fill in that gap, great. But I do not believe that when it comes time to confirm a plan, that litigation is going to be so valuable on that date that Mr. West's clients can be, residual beneficiaries. But that's an issue for another day. At the end of the day, Mr. West has come in with an extraordinary motion, and he's offered no proof whatsoever. And for that reason, the appointment of an official equity committee should be denied.
Your Honor. Thank you. So, Your Honor, first, I think it's important to note the ad hoc committee has made a couple of proposals to the debtors and to the official committee of unsecured creditors, and we certainly intend to engage with them on that front actively. And so the court's aware part of their proposal is they want to take advantage of the debt financing. And so we're interested to hear in how they intend to do that. I think the point of raising that note, Your Honor, is that certainly one of the factors here when you look at Pilgrim's Pride and maybe Core Scientific is that this particular ad hoc group has more than adequate representation. White and Case is more than capable of presenting and prosecuting the interests of these particular parties. In fact, they've already done it in some degree in trying to transfer venue of the cases. That's one. Two, so the court's aware, the debtors estimate that rescission claims in this case are in the high eight figures. Certainly we're waiting for the SEC.
Let me ask you about that. Because would they be subject to 510B?
Potentially. It depends, as Mr. Arlett, I think, highlighted, and he's right. You've got folks who've already sold and they're out. They may be damage claims. They may be, I was given my security, but I paid a price for it that was above or below market. So there may be financial damage claims, Your Honor, that would not be subject to 510B as well.
Tell me how that works. So, they would not be subject to 5. Well, they're not buying securities of
the debtor, right?
Of the debtor, but none of these parties have any relationship to the debtor, a direct relationship to the debtor.
Well, some of them, Your Honor, were sold shares in Link 2, so Liquid Shares actually does own a little bit of Link 2. So there's some of that. But an example would be a customer's told, sell me one of your Ripple shares, and prior management led by Mr. Saris, in one example of how they met a Ripple tender, went out and said, okay, I want you to give me one share of Ripple. In exchange for that, I'm going to give you 2 or 3 other securities. I'm going to diversify you and make your claim better. And it turned out those securities were either worthless or became worthless. And so someone gave up a share in Ripple for a below market number, now that we understand what those things were worth. And the company then went out, then Link 2 went out and sold those or tendered them to Ripple to bring the cash in to do other business. The delta in there, Your Honor, is a damages claim. And in that damages claim, we think that would be entitled to cash and not subject to subordination under 510B.
But who would it be entitled to cash from? Because none of these entities are dealing with Link 2. They're dealing with...
Oh, no, they are. Link 2 is... No, they're selling to Link 2 or they're trading with Link 2, Your Honor. So
Link 2 the debtor or Link 2 the non-debtor?
Link 2 the debtor, Your Honor. They're doing business with Link 2 Inc., the entity where the equity holders that are seeking a committee reside. So the rescission claims, Your Honor, would come in at the Link 2 level, not the Link 2 Liquid Shares level, the Link 2 level, the parent. That's where they would come in. They have damages claims. We think they're at a minimum, a high 8-figure claim. And the damages, we don't think that those are likely subject to Section 510. That's one. I'll give you a further example that we think is also similar. So Mr. Brody is here reserving rights for the Swagger Trust. Perfect example. The Swagger Trust sold Ripple shares to Link 2 and Link 2 Liquid Shares. They're now alleging that their sale, had they known that, and I'm going to roll my eyes, let me roll my eyes a little bit here, had they known that Link 2 or Liquid Shares were going to then distribute their sale to their customers through whatever vehicle they were supposed to do, that the Swagger Trust would not have sold shares to Link 2 or Liquid Shares. And so they have a damage claim now related to the sales that they made based on misrepresentations of 2. So while we think they're just, from the debtor's perspective, Your Honor, we think that the Swagger Trust is just an unhappy seller. Nevertheless, that would be the kind of claim that at least the Swagger Trust has asserted as damages, not subject to Section 510B, and they have differing views of how 510B applies in this case to the customers, for example. So those are examples, Your Honor, where we think there are real and substantial claims that are coming at the Link 2 level where the shareholders reside that put them far out of the money, to answer your question. So we think, Your Honor, there is really no dispute from the debtor's perspective that Link 2 as an entity is insolvent for the claims, the prospective claims that it did. I think Mr. Allett hit it right, that our Sullivan and Cromwell, our securities counsel, put it that they've seen bigger violations by a quantum in terms of securities issues. They've never seen more violations by just the sheer number of the laws broken by Link 2 during the process. So we think there's just claims that are coming. It's just a question of how they get paid, if at all. So, Your Honor, when we look at here for what the committee's here to do, there are a couple other issues. Number one, the ad hoc group has not filed a 2019 statement. We do not know the entities or the individuals that they represent. We certainly believe there are many of the shareholders, in particular the early ones, who either turned a blind eye to the fraud that was going on here, were knowingly benefiting from the fraud that was going on here. There was front running, we believe, Your Honor, in terms of how Link2 would sell securities and benefit those folks who were the larger investors early on. So we don't know who those people are. We don't know if we have claims against them. As Mr. West highlighted, the special subcommittee is still doing its work. We can't give Mr. Reisman and his team a list of those folks to see if there's claims to deal with. So that's a problem that we have here, Your Honor. We don't have a 2019 statement, so it's hard to truly vet who's coming. So with that, Your Honor, I think when you look at Core Scientific that says, what will the equity committee contribute here? We don't think, other than additional significant costs, Your Honor, to use Mr. Stein's word, the friction that would be caused by another committee being brought to this case to review what's going on, to make its own proposals, for the debtors to review it, for the official committee to review it, for Stanton to review it, for the U.S. Trustee's Office to participate. The friction, Your Honor, is an amount that just doesn't, back to my earlier expression, the juice just doesn't justify the squeeze, we think, for those added costs. So I think, given that the motion really fails to provide any evidence of its own to support its approval, I think it should be rejected out of hand, Your Honor. And bottom line, the equity committee or the ad hoc committee has its own agenda, and that's fine. But it does not have an agenda that these estates should be funding. And with that, Your Honor, we think the motion for the appointment of an equity committee should be denied.
Right. Did I understand you correctly that the change in the Schedule EF was to reflect the difference between the amount paid for the securities or the amount that was used to purchase the interest in the LLCs, supposedly, versus the market value of the securities on the filing date? Did I get that correct?
You do, Your Honor, at the end, at bottom. I think just to be clear about that for the record. So Liquid Shares always purchase securities with its own money. Once the wheel got started, Your Honor, with funding from some of the shareholders right about now, Liquid Shares bought the asset. Then it would turn around and sell those economic interests, purported economic interests that we don't think were properly set up, to the customers. And so, yes, Your Honor, the change to Schedule EF goes from now the funding to the purported economic interest that the customers are holding, which would then reflect, would encompass fair market value, Your Honor, of those assets.
Your Honor, if I could be heard a little bit on that point.
Yes.
So this is an issue that the committee and the debtors spent a lot of time on, and it was important to the committee because, in our view, regardless of if the committee is right or the debtor is right, on the filing date, people had a claim based on what was either in their account or supposed to be in their account. And so, to the extent the fair market value would need to be determined, this way you could do it sort of globally. Everybody who has share A gets the same value and litigate that in one fell swoop, rather than, if given the sort of initial buy-in, everybody would have had to file a claim if they thought that, for example, they were entitled to the value as of the filing date rather than their initial buy-in date. So the purpose from the committee's view was to avoid anybody needing to file a claim for their customer account while preserving the status quo of not resolving the issue of what exactly is that claim.
Have you heard your response briefly?
Yes. Go ahead.
So first of all, I just want to clear up one thing at the outset. It was not, as Mr. Schwartz said, White and Keith who led the effort to transfer venue. I just wanted to be clear about that from the beginning. To address Mr. Owlett's presentation, I commend Mr. Owlett fiduciary should be there to represent them. And obviously the market can speak to some extent, but we believe an estate fiduciary should be there for process-related concerns as it relates to the potential that there is actual value to the business. Mr. Owlett also essentially conceded the validity of subordinated government regulatory claims. Now, he has no incentive not to do so, right? But that is not skin off of his constituents' back, but it is skin off of the equities back. And I'm a little less clear about how Mr. Schwartz could come in as debtor's counsel and essentially do the same thing. But I think the point is all of this proof just establishes why it's critical that we have a fiduciary who is actually advocating specifically for the interests of equity. Because when you have both estate fiduciaries come in and say, Your Honor, there's going to be huge regulatory liabilities, they're going to be valid, they're going to be allowed, it's very clear that somebody's got to be there advocating for the interests of the shareholders. Your Honor, that's all I have unless you have any questions for me.
All right, does anyone else wish to be heard?
Yes, please, Your Honor. Gavin Solomon.
Yes.
Firstly, I'd like to wish to compliment you, Your Honor, on the open forum discussion, because this would never happen in Australia. So it's very enlightening. So thank you. Next, I'm not a member of the ad hoc committee. I knew nothing of the fraud. I'm the second or third largest shareholder of Link 2 and have been since 2019. And if we go to the question of costs that everyone sees,
Hand raised.
the real issue is there should not be a creditors committee. Unit holders are not creditors. There should be an equity holders committee, and unit holders are equity holders. So therefore, all we need to do, from what I propose, is that the creditors committee not be made up of unit holders and only be made up of trade creditors. And when you look at the trade creditors we've got, it's only several $1 million, but there's some real issues. The three of those creditors, two of the creditors are large law firms. They backed into the company since 2020. They've been involved in the SPPs. They've been involved in the SPAC. One of the law firms even has their partner attend every board meeting since 2020. They've charged millions of dollars. Shareholders, equity holders have seen $700 million of value be destroyed. That's in addition to the underlying Ripple shares and all that. So there's those law firms throwing the gun. Then you've got the auditors. The auditors are a creditor. They're only owed, several $100,000. They've already charged millions. But they gave unqualified accounts for 2022 and 2023, which were relied upon for the SPAC. So they're in the gun for $700 million. Then you've got the directors, past directors, current directors. There's litigation everywhere. Now, this litigation, that's an asset for equity holders. Equity holders are shareholders and unit holders. So we've got another, Mr. Schwartz, I want to compliment you on now trying to protect everyone, but you're not protecting shareholders. You've written to me specifically, and you quote specifically in Chapter 11, the duties of officers and directors are to creditors and not shareholders. So, close quote. So, Mr. Schwartz, I'd like to thank you so much, because that's the biggest viewpoint that warrants the formation of an equity holders committee. Because he's of the view, and clearly the other directors are of the view, that you don't have to look after equity holders. The court needs to be aware that Link 2 Council has 6 directors. 3 of those directors have been there since the fraud and bad actions took place. One of the directors is even a member of the special committee and was even one of the early funders of Link 2 Assets. The other 3 directors were appointed in 2025. The other 3 directors. During 2025, the directors set and then cancelled 3 equity holder meetings to elect directors. The directors ignored. I sent them a formal Section 211 of the Delaware Code requisition for election of directors to be held by 24th of June this year.
they ignored it. And then the directors, when confronted with a proxy spill motion, they went virtually the next day to file Chapter 11. So proceeding with the settlement without the equity holders committee essentially will wipe out all equity holders and may shield the directors from lawsuits with the court imprimatur. So I really press upon the court. There's no extra cost. There doesn't need to be the creditors committee. But look, the council that are involved in it can move across to the equity holders committee. Equity holders committee will be made up of unit holders and shareholders, and therefore everyone gets a say. The big problem also with the litigation fund, you know, there's 2,000 unit holders have invested some $40 million into the Link2 SPVs, and they own 20% of Link2, and they're going to get wiped out under the settlement plan. So why shouldn't the equity holders committee be the administrator of the litigation fund, acting for everyone? I'd like to thank you very much for letting me speak. Thank you.
All right. Does anyone else wish to speak?
Yes, Your Honor.
Yes.
Yes, this is the real crypto informant X-rated pennies, also known as Ron Davis. I'm understanding that during their settlement that the funds are going to be coming up out of the Ripple shares, and that's all I'm heard from the Ripple shares only. And based on, regardless if you're accredited or unit or shareholders, the Link2 shares, they are held, they may be held accountable later because of for the fraudulent or allegedly fraudulent or violation of numerous of security laws, and then that's going to help fund possibly some of the short that they're funding out of the shares. If that makes any sense.
It did make sense, but this is what we're talking about now is the appointment of an equity committee.
And
I think you're
that's what I'm saying.
You're referring to
the equity committee. The equity committee would be okay. I got you. But go ahead.
You're talking about the plan that's being discussed between the company and the creditors committee. That's not the form today. Okay. Does anyone else wish to be heard with respect to the equity committee? All right. I'm going to take the matter under advisement and issue a ruling or call you back to rule. I'll try to do that promptly within the next couple of weeks. I have to really think through this. I commend everyone on their papers, and they really have raised some issues for me that I need to think through. So we'll be in recess till Monday morning. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
I'm going to pick this up first.
God damn. Fuck. Well, ain't nobody gonna be happy. They just want to use. I'm trying to grasp my head around it. It sounded like to me that they just want to use the Ripple shares to fund the goddamn and the fund. They got 20 million and they want to use, and that's because the company sold those Ripple shares, but they sold them at a higher price than they brought them, and then they sold them to other motherfuckers at a higher price too. But they were getting them real cheap, and they were selling them high to every motherfucking body else. And they sold them bitches, and so now we don't got those shares, and they want to use the shares that we do got to fund that shit. And they saying any profit that was made off of, they gonna take that profit and make us whole. Maybe that's what I'm grasping. But we're gonna have to more to be real. And I actually fell asleep during the hearing, so I missed some stuff. But It's a lot of information. I guess we'll be back Monday to take a listen to things like that, man. Thanks for having me again. I think we're done for the day. I'm going to listen to John Deaton tomorrow on Twitter. He's going to have a thing going on, and we're going to go from there. So I'm going to let that be the word. Know what you hold. Know what you hold. This is for entertainment, educational purposes. Get your bag together. XRP, XLM, XDC, crypto crazy, pennies.